We first met in early 2001 through our Duke affiliation when Dean had recently been named Deputy Chief of Staff to Vice President Cheney. And, I called him. I was coming to Washington from Duke and suggested we get together and talk. And I had worked a lot in the previous administration as a foreign policy advisor to Vice President Gore, not on the staff, but from the outside. And he said, "That's great. Let me tell you where my office is. Do you know how to find the old executive office building?" I said, "Yeah, I think I know where it is." Second floor, right? It's the second floor. And I get to the building, and a lot had changed. The guys, the security guards downstairs were the same. The pictures on the wall were different. It was one of those sort of surreal experiences. He had just been named the staff, was unpacking his boxes, and I could see sort of the marks on the walls and I knew what pictures had been where. But Duke affiliations are one of those wonderful things in life that kind of bring you together. And politics doesn't matter nearly as much as the common ground that you can develop through Duke affiliations. Dean had been a student here and got his bachelor's with distinction in economics in 1975. I had not gone to school here, but remember the Duke faculty. And the bottom line really is, we share a lot of goals, which is we all care about trying to interest people in publics and public affairs, engage our universities and Americans in general in the issues of the day. And we had hoped to bring Dean a few months ago to the Sanford Institute for a talk, and we were unable to kind of pull it off at that point. So when Scott was organizing the conference and we started talking about issues, and we didn't quite know where the Iraq issue would be, but Dean teaches as an adjunct faculty member at the Georgetown School of Law and teaches a course on the theme of which he's going to speak to us tonight, War Powers in the Constitution. And figured, well, what a great timely topic to be able to have someone who, both through his professorial distinction and through his work on a day-to-day basis, could speak to this topic. He's had a very distinguished career in Washington. Prior to working for Vice President Cheney, he worked on Capitol Hill as a chief of staff and key staff member to Congressman Chris Cox of California, both in committee capacities and personal staff capacities. Prior to that, served in the executive branch, the Treasury Department, as a lawyer, in the White House in 92, 93, in the first Bush administration. In addition to his Duke degree, he's a graduate of the University of Nebraska College of Law, and has really worked very hard in many different ways on so many different issues. And his talk tonight will be on war powers in the Constitution. And so it's really just great, and we really appreciate, we can only imagine what you left behind to make this visit to Duke, and we appreciate it for all the more for that reason. So please join me in welcoming Dean McGrath.
Thank you, Bruce. It's certainly a pleasure for me to come back to Duke. I'd also like to thank Scott, the Center on Law and Ethics and National Security, and the other sponsors for inviting me to be a part of the conference. As Bruce mentioned, certainly a well-timed conference. Whoever could have thought that by putting it together at this stage would have put the conference right in the middle of the events in Iraq. So congratulations to the sponsors for being particularly timely. I'm particularly excited about returning to Duke at the request of law school. Although I should probably be more honest with my host, I was once admonished by Duke security, never return to Duke at night. Luckily, it was so long ago, I forgot what the infraction was. I certainly hope they have. I also realize that everyone is at the end of a long day, and you're looking forward to a titillating speech by another lawyer and part-time professor. Well, I can't promise titillating, but I'll try not to drone on for too long. As Bruce mentioned, today as we consider the many challenges we face, I'd like to take a moment to reflect on the genius of our Constitution in setting the public policy principles as well as the legal norms that help frame our current approach to the war on terrorism. As the President stated earlier this week in Belfast, we believe that free nations have the responsibility to confront terrorism, to oppose the spread of weapons of mass destruction, to advance human rights and dignity across the world. We believe that the just demands of the international community must be enforced, not ignored with impunity, and we are acting on these convictions wherever security must be defended and wherever peace can be achieved. In my view, the actions we are taking to meet the threat of terrorism are simply the latest evidence of the sheer genius of the framers of our Constitution. In one document, they fashioned a political system, a legal framework, and normative legal rules that have passed the test of time. It's hard to imagine a political system better suited to accommodate competing views, minority interests, and the will of the people. Equally as important, the Constitution has established legal norms that are the essence of the rule of law. In considering the genius of the Constitution, I'd like to start at the beginning with its preamble. The preamble is a remarkably concise and clear articulation of the aspirations and principles that have guided and continue to guide our nation's leaders. It states, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." The preamble does not set forth normative legal standards, but as the Supreme Court has opined in classic decisions such as McGrath versus Maryland, it makes clear that the Constitution and its legal norms derive their legitimacy directly from the people. While not doctrinally significant, the preamble may have some interpretive value, or as a colleague of mine suggested, maybe we should refer to it as legislative history on steroids. Tonight, I'd like to consider briefly how the preamble's public policy principles can help inform our current approach to the war on terrorism. The preamble's first admonition is to form a more perfect union. Primary responsibility for the war on terrorism is certainly national in nature. Today, who can doubt that the American people, and for that matter, much of the world, look to the President and the United States government for leadership. Politically, the President and Congress view the war on terrorism as a national issue for which they are responsible and will rightfully be held accountable by the American people. As a normative matter, the Constitution has assigned these responsibilities to the national government. Both Articles 1 and Articles 2 set forth a broad array of authorities for the President and Congress to deal with the threat of terrorism. This primacy clause makes clear the primacy of the national government. And the Supreme Court has repeatedly spoken of the need for the country to speak with one voice in dealing with foreign threats. Clearly, the goal of maintaining a more perfect union is one that our nation's leaders are working to attain. However, as the tragic events of 9/11 made clear, much of the responsibility for homeland defense, including the shared responsibility for identifying possible threats and the first response to terrorist incidents, rests largely with state and local officials. Once again, the Constitution recognizes this reality by limiting the authority of the national government and reserving to the states the general police power. The recognition of this limited authority is, of course, a part of the structure of the Constitution. And without getting into a long jurisprudential discussion of federalism principles, is reflected in the 10th Amendment. By fashioning this unique blend of national and state authority, the founders set forth a framework of government that has continued to serve us well in the current war on terrorism. The second admonition is to establish justice. The jurisprudence of justice is a subject far beyond tonight's remarks. There are, however, a couple of aspects of the concept that are at the heart of the war on terrorism. First, as numerous scholars have noted, justice is fundamentally a moral concept. In this sense, the attacks of 9/11, which targeted innocent victims, were entirely unjust, and the calls by the President, members of Congress, to bring the perpetrators to justice, defined both narrowly in the criminal law sense, as well as more broadly in terms of holding those who harbor terrorists responsible, are consistent with this moral concept. In addition to its moral foundations, the concept embodies John Rawls' view of justice as fairness. In the context of a just war, Rawls has concluded that a just nation will aim above all to maintain and to preserve its just institutions and the conditions that make them possible. It is not moved by the desire for world glory or power, nor does it wage war for purposes of economic gain or the acquisition of territory. These ends are contrary to the conception of justice that defines a society's legitimate interest. I would argue that our current efforts to protect the homeland and the American people from further terrorist attack, and to identify and act against terrorists whose very aims are to destroy our society and its institutions, are clearly within Rawls' concept of a just war. The motivation of the United States in pursuing the war on terrorism would seem to fulfill the preamble principle to establish justice. The essence of the war on terrorism is embodied in the preamble's phrase, provide for common defense. Today's challenge is how to win the war on terrorism and protect the American people from attacks like those of 9/11. In order to be successful, we must identify and take steps to counter terrorist threats before they become terrorist acts. The prospect of having to wait out a first strike from an adversary with weapons of mass destruction, as some have argued, is not, in my view, consistent with our constitutional responsibilities required by constitutional norms, nor required under international law. As Professor Gene Rostad often noted, the Constitution is not a suicide pact. Yesterday, the Vice President, in his remarks to the American Society of Newspaper Editors, captured the essence of this principle in connection with the war on terrorism and Operation Iraqi Freedom. He stated, in removing the terror regime from Iraq, we send a very clear message to all groups that operate by means of terror and violence against the innocent. The United States and our coalition partners are showing that we have the capacity and the will to wage war on terror and to win decisively. The 9/11 attack forced us to come to grips with the possibility that the next time terrorists strike, they may well be armed with more than just plane tickets and box cutters. The next time they might direct chemical agents or diseases at our population or attempt to detonate a nuclear weapon. These are not abstract matters to ponder. They're real dangers that we must guard against and confront before it's too late. The Vice President continued, the government of the United States has a moral duty to confront these threats and to do whatever it takes to defeat them. We have a further responsibility to help keep the peace of the world and to prevent the terrorists and their sponsors from plunging the world into horrific violence. If we are to protect the American people and defend civilization against determined enemies, then we cannot rely on the old Cold War remedies of containment and deterrence. Containment does not work against a rogue state that possesses weapons of mass destruction and chooses to secretly deliver them to terrorist allies. Deterrence does not work when we are dealing with terrorists who have no country to defend, who revel in violence, and who are willing to sacrifice their own lives in order to kill millions of others. It's this alliance between terrorist networks seeking weapons of mass destruction and rogue states developing or already possessing these weapons that constitutes the gravest threat to America's national security. Therefore, a vital element of our strategy against terror must be to break the alliance between terrorist organizations and terrorist-sponsoring states. I believe the Constitution provides the normative legal authority to meet the challenges of the war on terrorism and to accommodate the strategy of anticipatory self-defense in the context revealed by the attacks of 9/11. This is not a new doctrine. Since the earliest days of the Republic, the United States, like other countries, has used force and threatened the use of force to protect its interests. The constitutional debate about the war powers has focused principally on the internal allocation of these powers between the President and Congress. For the most part, the courts have, in my view correctly, deferred to the political branches in determining the normative legal rules governing the allocation. This does not mean, of course, that the legal answers concerning these responsibilities are easy. That's why there's so many government lawyers. But the Constitution's legal norms have provided a remarkably stable policy concerning the use of force that friends and foes have understood internationally and that the American people have understood and accepted domestically. Once again, the founders established a political process and legal norms that have accommodated the debate about the legitimate use of force in behalf of the American people. In considering the preamble's direction to promote the general welfare, this clause reiterates what every elected official knows. The welfare of the American people is of paramount importance. The combination of this principle, which is a good encapsulation of the President's and Congress's domestic responsibilities, with the common defense principle, summarizes the primary responsibilities of the national government. The framers recognized that foreign and domestic responsibilities would have to be met simultaneously. Today, the President and Congress are focused on Operation Iraqi Freedom, the budget resolution, the supplemental appropriation, the President's economic growth package, and a number of other matters at the same time. Once again, the Constitution has reflected the structure of the American system in a unique and particularly effective way. The final clause of the preamble I'd like to consider is in some ways the most important. To secure the blessings of liberty to ourselves and our posterity. Last summer, Assistant Attorney General Viet Dinh, former Georgetown law professor, addressed the issue of what we mean by liberty in the context of the war on terrorism. In answering that question, he stated, here, I think Edmund Burke puts it best. The only liberty I mean is a liberty connected with order, that not only exists along with order and virtue, but which cannot exist at all without them. In other words, ordered liberty. Order and liberty under this conception are symbiotic. Each is necessary to the stability and legitimacy that is essential for government under law. And that true liberty exists only in an ordered society with rules and laws that govern the behavior of the man. The President has eloquently described the principle of liberty as follows. The power and appeal of human liberty is felt in every life and every land, and the greatest power of freedom is to overcome hatred and violence and turn the creative gifts of men and women to the pursuits of peace. Certainly, the concept of liberty has been a driving principle for our country's leaders since the Declaration of Independence and the Revolutionary War. In considering the principle of liberty, the framers of our Constitution, including General Washington and other military officers, were acutely aware that the use of force is not an abstract concept, but too often requires the ultimate sacrifice by those fighting in defense of our freedom and liberty. The men and women who gave their lives in New York City, at the Pentagon, in Pennsylvania, in Afghanistan, in Iraq, and in numerous other places throughout the world embody this principle of liberty and freedom. They deserve our deepest honor and respect for making this abstract concept of liberty a reality. I'd like to close with a brief summary of the essence of the rule of law by Friedrich Hayek. Nothing distinguishes more clearly the conditions in a free country from those in a country under arbitrary government than the observances in the former of the great principles known as the rule of law. Stripped of all technicalities, this means that government in all its actions is bound by rules fixed and announced beforehand. Rules which make it possible to foresee with fair certainty how the authority will use its force and power, given circumstances, and to plan one's individual affairs on the basis of this knowledge. In the current war on terrorism, the Constitution has once again provided us with the needed guidance, both as a matter of public policy and as a matter of law. Thank you.
We got a little bit of time for any questions to Dean. So I'll sort of help sort out. Anybody has a question, you raise your hand, we'll recognize you, and I'll turn the mic back to Dean. Right here.
Coming from your former colonial power, which has the defect of not having a constitution as you understand it, I am in fact a great fan of the US Constitution. On the last significant birthday I had, I requested from my parents a birthday cake with a Jefferson memorial. I proposed that the building should be in marzipan coated with icing and Jefferson should be in licorice. I can get it. In that context, could you tell me what you think your founding fathers, and I mean the original founding fathers, would have said about the fact there is currently a US citizen in jail without access to a lawyer because he's been labelled as an enemy combatant? And what your founding fathers would have said about the fact that there are people who are being detained by American authorities outside US territory who are again being denied access to a court. Is this consistent with what your founding fathers thought they were doing?
I mean, not only would it not have come as a surprise to me, but at the time of the founding of the Constitution, it would be relatively regular practice. In fact, much of the early debate about the Alien and Sedition Acts goes to much of the exact same issue we're raising today. So, in that sense, as an original interpretive matter, it certainly wouldn't have been something that would have been considered beyond the bounds of the Constitution. That was, I mean, that's what the entire Alien and Sedition Acts debate was about, was the ability to imprison for seditious statements by U.S. citizens. Now, we can argue. I mean, we can argue about, whether the determinations were right, whether the acts were right, whether it's an appropriate determination. But if you're asking me if it's something that was within understanding or purview of the founding fathers, almost certainly.
We've got a roving mic, so if there's other questions. Over here.
Mr. McGrath, thank you for coming this evening. My name is Randall Cook. I'm a student here at Duke University School of Law. I have two questions. First, I'm interested in your thoughts on the continued relevance of the Declaration of War of the Constitution and the executive's powers, whether you think that the executive's powers are qualified or in any way diminished when there's not a formal declaration. In other words, if the current system of joint resolutions by Congress is adequate and has replaced essentially the declaration of war in our system. And then second, I would appreciate it if you would comment generally on the compatibility of the Constitution as a founding document to guarantee a system of order of liberty in our own society, and the competing, perhaps competing, obligation and responsibility of being an empire of liberty in the world today. with the new obligations that the U.S. certainly has had since the conclusion of World War II, but certainly as dramatically demonstrated by our current war in Iraq and responsibilities there, to what extent do you think that the Constitution is compatible with and enables the executive powers to sustain that system of order and liberty, not only here, but around the world? Thank you.
With respect to the first, the declare war provision, I think that there is a pretty good argument that the declare war provision means what it says. Declare war. But with respect to whether that is the embodiment of all congressional authority with respect to war making within our constitutional system, I think the answer is clearly no. The declare war provision is one of probably 10 provisions in Article 1 that relate in some manner to congressional authority with respect to war, the use of force, the projection of force. So I think that when people argue that the declare war provision is essentially the entire embodiment of Congress's authority in the area, I think that's not the correct view. However, I do think that Congress has a number of other authorities, so that not only is the declare war provision not the only affirmative grant of authority, it also isn't the flip side, which is a limitation on the authority. So Congress isn't required to act solely through the declare war provision to provide authorization. Now, in situations like Afghanistan, Iraq, where you've got influence of both the executive and legislative authority, you've got under Justice Jackson's concurring opinion in Youngstown Steel, basically the confluence of the entire authority of the United States as a nation state within the system. So the short answer is I don't think that there's a very good argument that Congress is restricted to acting through the declare war provision. There are actually a fair number of cases to that effect. First of all, the courts tend not to get involved in this issue, leaving it, in my view, rightfully with the political branches. Members of Congress have tried to sue to say that activities can't be authorized, they have to go through the declare war provision. Very few members of Congress sign on to those, and they are routinely dismissed. So I think that's probably not a very viable argument in terms of the authority of Congress. And I think the best argument is that Congress does have the authority through all its other provisions to authorize the use of force. The second question, which I managed to filibuster by answering so long at first, I can't remember.
Whether or not the Constitution is compatible with the sort of empire of liberty obligations of the United States and the world today. To what extent we can both preserve our system of order and liberty here, and also at the same time sustain our obligations as the guarantor of stability and hopefully freedom abroad.
Well, what I'd argue is that the preambular admonition is in terms of establishing a constitutional order for the United States. It's the people and the people providing in order to establish liberty. So that in that sense, it's directional to the national government with respect to the rights and liberties of the American people. The issue of the motivation censoring liberty and freedom to peoples outside the United States strikes me as a perfectly legitimate interest of the United States, that certainly is a commendable aim of the United States foreign policy, but that it's not derivative in a direct sense from the constitutional provision.
Sir.
John Brooks of Raleigh, North Carolina.
Microphone goes right to you there.
John Brooks of Raleigh, North Carolina. I'm interested in the situation where, of course, you didn't really discuss it, the fact that a world collective security system was put in place in 1945 with the adoption of the UN Charter, and our signatures on charters and conventions become part of the law of the United States. When we go to war, we're very interested apparently in the protection of both military and civilian people and prisoners under the Geneva Conventions that were promulgated in 1950 pursuant to part of the United Nations institution. Is there any concern in this administration about the disengagement of the effectiveness of the Geneva Conventions that have the same efficacy as the Charter of the United Nations when we in fact ignore compliance with the requirements of the Charter of the United Nations?
Got the wrong person to speak in behalf of the administration on that issue. I mean, as a general proposition. I'm sorry. I am not the expert on the United States particular compliance with the various international instruments. So to a certain extent, I'm the wrong person to ask the question about. I don't know the specifics of the provisions you're speaking to. It is not, it is in part our administration's position that we consider compliance with our international obligations as something we take seriously. But with respect to the specifics you're mentioning, I'm not an expert on those.
Sir.
I'm Steve Dykus from Vermont Law School. In every great emergency, the people of the United States have renegotiated the bargain we struck with ourselves in this representative democracy about access to information about the government. The Bush administration has become, especially since 9/11, enormously less transparent than any administration in recent memory. I'd be interested in your views of just how we should renegotiate that bargain, that is, to enable the electorate to know what it needs to know to produce fair accountability for our government under the circumstances. And if we're going to change the rules at this point, how long will the new rules have to stay in place?
Well, first of all, with respect to the availability of information, one of the decisions we made in terms of embedding journalists with forces in place in Iraq is one of the most revolutionary, making information available in real time to the American public about ongoing operations. So I guess I don't accept the premise that the administration is taking all of these steps not to provide information. The access that's been provided to current operation is unprecedented. There's real-time access. Reporters aren't going through censors. Their information isn't being withheld. They're on the front lines as the tragedy of reporters being killed in action. So it strikes me that the argument that somehow we restricted access, we're not providing information, I guess I don't agree with the fundamental premise of the question.
I think we'll, it's been a long day. Did you have a question? We'll take one last question then. Looked like you had a question that you wanted to ask, so we'll get the microphone over to you. Okay.
Yeah, I'm Lenny Newman, I'm not just Lenny, I'm Lenny Newman, and I have no law degree or whatever. But I've been listening to people since 8:30 this morning, and I have from each speaker taken away something that I can really think about. Tell me your message. What am I supposed to be going home thinking about what you want to provide us?
Well, I guess the message that I would want you to take home is that the preamble to the Constitution includes directions to policymakers, national officials, about how we order conduct that has applicability in today's war on terrorism, and that a document that is 220 whatever years old it is has continuing viability, both as a public policy document, a political document, and a legal document.
Thank you for the question. Thanks for the answer. It's been a long day. It's at 8:30 this morning. The little digital here says 8:45, and I think it's caught up with daylight savings time. Scott, do you have any marching orders to folks? No. Just come back for more. I really want to thank all of you, and I really want to thank Dean for being with us tonight, for taking the time out to reflect both on the immediate issues of the day and the larger context, historical context and legal context of the Constitution. So please join me in thanking Dean McGrath, and also looking forward to seeing you all with all of us tomorrow. So thanks very much.